aspect because though right of hereditary succession abolition was upheld, and though it was held that appointment of an archaka is a secular activity, because of the concession of the learned advocate general appearing for the state of Tamil Nadu, that it will be in accordance with the practices of the temple, that is agamas, etc., then it was upheld. Now kindly come to para 15, page 382. Middle of about the 8th line, by Rule 12, it also ensured that the archakas would be proficient in the mantras, Vedas, Prabandhams, Tevarams, etc., and thus be fit for the performance of the puja. In other words, that he would be a person sufficiently qualified for performing the rituals and ceremonies. As already shown, an image becomes defiled if there is any departure or violation of any of the rules relating to worship. And this risk is avoided by insisting that the archaka should be an expert in the rituals and the ceremony. By the Amendment Act, the principle of next in line of succession is abolished. Indeed, it was the claim made in the statement of objection reason, hereditary principle of appointment should be abolished, and that office should be thrown open to all candidates trained in recognized institutions. The trustee, so far as the amended section 55 went, was authorized to appoint anybody as an archaka in any temple, whether Saivite or Vaishnava, as long as he possessed a fitness certificate from one of the institutions referred to in Rule 12. Rule 12 was a rule made by the government under the Principal Act. That rule is always capable of being varied or changed. It was also open to the government to make no rule at all or to prescribe a fitness certificate issued by an institution which did not teach the agamas or traditional rituals. Result would therefore be that any person, whether he is a Saivite or Vaishnavite or not, or whether he is proficient in the rituals appropriate to the temple or not, would be eligible for appointment as an archaka, and the trustee's discretion appointing archaka without reference to person and other qualification of archaka would be unbridled. Trustees to function under the control of the state, because under Section 27 of the Principal Act, the trustee was bound to obey all lawful orders issued under the provisions of the Act. Then para 60, it has been recognized for a long time that where the ritual in the temple cannot be performed, except by a person belonging to a denomination, purpose of worship will be defeated. In that case, the claimants to the temple and its worship were Brahmins, and the daughter son of the founder and his nearest heirs under the Hindu law. But the claim was rejected on the ground that the temple was dedicated to the sect following the principle of Vallabhacharya, in whose temples only the Gosains of that sect could perform the rituals and ceremony. And therefore, the claimants had no right to either to the temple or to perform the worship. In view of the Amendment Act and its hours of, there was nothing in the petition submission to prevent the government from prescribing a standardized ritual in all temples, ignoring the agamic requirements, and archakas being forced on temples from denominations unauthorized by the agamas. Since such a departure, as already shown, would inevitably lead to the defilement of the image, the powers thus taken by the government under the Amendment Act would lead to interference with religious freedom guaranteed under Article 25 and 26 of the Constitution. The force of the above submission...
How did they apply it?
Yes. Now, Millard, the Advocate General concedes. Please see, Millard. The force of the above...
But this is all dealt with in the other judgment, if I am not wrong.
Millard, it is that is Aditya, and Millard, Adi Shivacharya. Two judgments. Millard, I propose to deal with them. Millard,
the para 18.
Yes. Let's kindly see last 4 lines of this page, 383. Advocate, he did not also admit that he was bound by either the statement of objection reasons or the reiteration of the same in the counter. His submission was that we have to take the Principal Act as it now stands after the amendment and see what is the true effect of the same. He contended that the power given to the trustee under amended Section 55 was not an unqualified power because In his submission, the power had to be read in the context of Section 28, which controlled it. Section 28(1) provides as follows: subject to provisions of the Tamil Nadu Temple Entry Authorization Act, trustee of every religious institution is bound to administer its affairs and to apply its funds and property in accordance with the terms of the trust, the usage of the institution, and all lawful directions which a competent authority may issue in respect thereof, and as carefully as a man of ordinary prudence would deal with such affairs, funds, and properties as if they were their own. Learned Advocate General argued the trustee was bound under the provision to administer the affairs of the temple in accordance with the terms of the trust and the usage of the institution. If the usage of the institution is that the Archaka or Pujari of the temple must be of a particular denomination, then the usage would be binding upon him, and he would be bound to make the appointment under Section 55 in accordance with the usage, appointing one from the particular denomination. There was nothing in Section 55 in his submission which released him from his liability to make the appointment in accordance with the said usage. It was true that the principle of next in line of succession was not binding on him when making the appointment of a new Archaka, but in his submission, that principle is no part of the usage, the real usage being to appoint one from the denomination. Then Miller, reference is made to C.P. Ramasamy committee, to which my learned friend also made a reference that there is a crying need for reform, malpractices, etc. Then Miller, parallelly, we have found no difficulty in agreeing with the learned Advocate General. At Section 28(1) of the Principal Act, which directs the trustee to administer the affairs of the temple in accordance with the terms of the trust or the usage of the institution, would control the appointment of the Archaka to be made by him under the amended Section 55 of the Act. In a Saivite or Vaishnavite temple, the appointment of Archaka will have to be made from a specified denomination, sect, or group in accordance with the directions of the Agamas governing those temples. Failure to do so would not only be contrary to Section 28(1), which requires the trustee to follow the usage of the temple, but would also interfere with the religious practice, the inevitable result of which would be to defile the image. Then Miller, hereditary principle is referred to. I am not advocating for hereditary principles. Let's kindly now come to page 386, third, fourth line. Therefore, it cannot be denied as a fact that there are several temples in Tamil Nadu where the appointment of an Archaka is governed by the usage of hereditary succession. The real question, therefore, is whether such a usage should be recorded as secular usage or religious usage. The court says that it's secular. Then Miller, para 21. It is true that a priest or an Archaka, when appointed, has to perform some religious function, but the question is whether appointment of a priest itself is a secular function or a religious function. Then the court goes on to hold that the appointment is a secular function. Let's kindly come to page 387, second line. But we are afraid such an illustration is inapt when we are considering the appointment of an Archaka of a temple. Archaka has never been regarded as a spiritual head of any institution. He may be an accomplished person, well versed in the agamas and rituals necessary to be performed in the temple, but he does not have the status of a spiritual head. Then again, the assumption made that the Archaka may be chosen in a variety of ways is not correct. The Dharmakarta, the Shaivite, make the appointment of Archaka, and the Archaka is the servant of the temple. It has been held in Seshadri Iyengar that even the position of hereditary Archaka is that of a servant subject to disciplinary power of the trustee. Therefore, the conclusion about the middle of the page, that being the position of an Archaka, act of his appointment by the trustee is essentially secular. He owes his appointment to a secular authority. Any lay founder of a temple may appoint the Archaka. Shaivites and managers of temples exercise essentially a secular function. And then Miller, towards the end of that page, last 4 lines, it would only mean that in making the appointment, the trustee is limited in respect of the sources of recruitment. Instead of casting his net wide for selecting a proper candidate, he appoints the next year of the last holder. That after his appointment, Archaka performs worship is no ground for holding that appointment is either a religious practice or a matter of religion. In view of subsection 2 of section 55 as it now stands amended, choice of trustee in the matter of appointment of Archaka is no longer limited by operation of the rule of next in line of succession. In temples where the usage was to appoint the Archaka on the hereditary principle, trustee is not bound to make the appointment on the sole ground that the candidate is the next in line of succession to the last holder. To that extent, and to that extent alone, the trustee is released from the obligation imposed on him by Section 28 of the Principal Act to administer the affairs in accordance with that part. Therefore, even if that was the usage, hereditary, that to that extent alone, that usage he can be departed from. The trustee is released from that obligation. The legislation in this respect, as we have shown, does not interfere with any religious practice or matter of religion and therefore is not invalid.
One minute. We placed on 3 principles. One is that appointment is a secular act. Number 1, that appointment must endeavor to continue the requirement of appointing within that denomination, and there is no hereditaryship. It's as simple as that.
And in accordance with the usage and customs of the temple and the agama.
No dispute.
And but usage can be departed from only to the extent of not following the hereditary right. Sure. That's all. That's the only thing. Now, para 24, it was, however, submitted before us that the state had taken a power under section 116(2).
So, Vaijanathan, your argument is that Sheshamma lays down the principle that does not authorize deviation from denominatory requirement. That's all.
Correct. That's a point.
Your point is taken.
Yes.
Next.
That's a point, that I want to take, because today, the power that has been conferred is to appoint anybody who fulfills this qualification. That can't be. That will be completely. Ultimately, people go to temple because of the faith and belief. If that faith and belief is shaken by somebody who, according to them, is not a person who is entitled to perform the worship by touching the idol, etc., then the sanctity of the temple is gone. That's the ultimate. Therefore, then paragraph 24, the power which has been conferred on the state to prescribe qualification is considered. And kindly see, middle of the page, in our opinion, last 15 lines of that paragraph, in our opinion, the apprehensions of the petitioners are unfounded. Rule 12 referred to above still holds the field. And there is no good reason to think that the state government wants to revolutionize temple worship by introducing methods of worship not current in the several temples. Rule-making power conferred on the government by Section 116 is only intended with a view to carry out the purposes of the Act, which are essentially secular. Act nowhere gives the indication that one of the purposes of the Act is to effect a change in the rituals and ceremonies followed in the temple. On the other hand, Section 107 of the Principal Act emphasizes that nothing contained in the Act would be deemed to confer any power or impose any duty in contravention of the right conferred on any religious denomination or any section thereof by Article 26. Similarly, 105 provides that nothing contained in the Act shall save us otherwise expressly providing the Act.
All right. What's the next?
Yes. Kindly see the last 4 lines. Moreover, if any rule is framed by the government which purports to interfere with the rituals and ceremonies of the temple, the same will be liable to be challenged by those who are entering the temple. Now, the next, in chronologically, when in Kerala, a similar provision was made in regard to appointment of Shantikas or Archakas, etc. That case came up, that is the Aditya. That is in my learned friend, yes, in Mr. Bhatt's compilation. Page 638, because this is heavily relied upon subsequently that in the another Tamil Nadu case, Adi Shivacharya case.
These are written submissions. He is saying compilation.
And the recent division bench judgment of Kerala High Court took the view that this judgment authorizes them to select anybody, Shantikar, and irrespective of caste, the particular adherence to agamas, etc., is irrelevant. That has come up for my lord's consideration on the case. Now, kindly see the question in the opening paragraph, page 645. 645.
It's 645.
The judgment starts at page 638.
What you give number to this, each one so many.
A bench of 2 honorable judges, page 638.
क्या compilation है? कितने compilation का एक numbers डाल देना, नहीं तो confusion होगा. Whose compilation is this? How many compilations?
Bigger compilation is of Mr. Bhatt.
Please do something. Some nodal council will take charge and give numbers to this. Somebody, Pratik, both of you sit down and then give numbers, please. Which one, what do you want us to do? By lunchtime, you tell us when we sit back.
Yes, my lord, we'll do it over lunch.
Mr. Dhawan also gave some compilation.
Yes,
so
yes.
therefore, give numbers.
We'll do that.
2, 3, 4 according to the councils. Okay, all right.
Page 638, the judgment starts, Adityan. And at 645, the opening paragraph.
649.
645.
But has shown us this, I think.
38 at 645 minutes. The question.
Huh?
The question that is sought to be raised in the appeal is as to whether the appointment of a person who is not a Malayalam Brahmin as Santikar or Pujari of the temple in question, Kongarapalli Neerikot Siva Temple at Alangad village in Ernakulam district, Kerala, is violative of the constitutional and statutory right of the appellant. A proper and effective answer to the same would involve several vital issues of constitutional and social, public importance, etc. Now, let kindly come to page 659, paragraph 70. where a temple has been constructed and consecrated as per agamas, it is considered necessary to perform the daily rituals, pujas, and recitation as required to maintain the sanctity of the idol. And it is not that in respect of any and every temple. I'm sorry, page
Yeah, you read it?
659, 659, para 70.
Okay. Where a temple has been constructed.
Yes, that's it. Where a temple has
As per agamas, it is considered
and
necessary to perform the
consecrated as
daily
per
rituals,
agamas.
pujas, and
It is considered necessary to perform the daily rituals, pujas, and recitations as required to maintain the sanctity of the idol. And it is not that in respect of any and every temple, any such uniform rigor of rituals can be sought to be enforced. Deharsh its origin, the manner of construction, or method of consecration. No doubt, only a qualified person, well versed and properly trained for the purpose alone, can perform pujas in the temple, since he has not only to enter into the sanctum, but also to touch the idols installed there. It therefore goes without saying at what is required and expected of one to perform the rituals and conduct pujas. He should know the rituals to be performed and mantras as necessary to be recited for the particular deity. And the method of worship ordained or fixed therefore. For example, in Saivite or Vaishnavite temples, only a person who learns the necessary rites and mantra, conducive to performed and recited in the respective temples, and appropriate to the worship of particular deity should be engaged as archaka. If traditionally or conventionally in any temple, all along, a Brahmin alone was conducting pujas or performing the job of sanskar, it may not be because a person other than a Brahmin is prohibited from doing so because he is not a Brahmin, but those others were not in a position, matter of fact, were prohibited. This is all, maybe, but this is not what Seshamark says. It talks about whatever was the custom. Now, custom and usage. Now, please see the conclusion arrived at. Consequently, there is no justification to insist that a Brahmin or Malayalam Brahmin in this case alone can perform the rite and rituals in the temple as part of the rights and freedom guaranteed in Article 25, and further claim that any deviation would amount to violation of any such guarantee in the contrary. There can be no claim based upon Article 26. So far as the temple under our consideration is concerned. Now kindly mark this, Miller, because in this case, nothing has been proved. So there can be no claim based upon Article 26. So far as the temple under our consideration is concerned, apart from this principle enunciated above, as long as anyone well versed and properly trained and qualified to perform the puja in a manner conducive and appropriate to the worship purpose of the deity is appointed as Sanatikaran, rehearse the degree based on caste, no valid or legally justified grievance can be made in a court of law. There has been no proper plea or sufficient proof also in this case of any specific custom or usage specially created by the founder of the temple or those who have the exclusive right to administer the affairs, religious or secular, of the temple in question, leave alone the legality, propriety and validity of the same in the changed legal position brought about by the Constitution, the law enacted by Parliament. Temple also does not belong to any denominational category and any specialized form of worship peculiar to such denomination or to its credit. For the said reason, it becomes in a sense even unnecessary to pronounce upon the invalidity of any such practice being violative of the Constitution. This is the ratio of this judgment. Some observations made elsewhere in some of the parts of the judgment which really were not necessary for the ultimate decision, because on the facts nothing has been shown in regard to either the denominational character or the usage and custom of the temple. Therefore, it is unnecessary to go into it. Now, this judgment is thereafter relied upon in the subsequent judgment. I want to show that.
Where Seshamal is mentioned in the last line.
Yeah.
But I don't know this is that.
Yes, I'll read. Now, my lord,
None of the earlier.
rendered before Seshamal case,
To
related.
read a little bit above also. The decision Sirur, but from there you read.
Very well, very well. The decision in Shirurmat case and the subsequent decisions rendered by this court had to deal with the broad principles of law and the scope of the scheme of rights guaranteed under Article 25 and 26 of the Constitution in the peculiar context of the issues raised therein. The invalidation of a provision empowering the commissioner and his subordinates as well as persons authorized by him to enter any religious institution or place of worship in any unregulated manner by even persons who are not connected with spiritual function as being considered to violate rights secured under Article 25 and 26 of the Constitution of India cannot help the appellant to contest that even persons duly qualified can be prohibited on the ground that such person is not a Brahmin by birth or pedigree. None of the earlier decisions rendered before Seshamal case related to consideration of any right based on caste origin, and even Seshamal case dealt with only the facet of right claimed on the basis of hereditary succession. The attempted exercise by the learned senior counsel for the appellant to read into the decisions of this court in Shirurmat case and others something more than that, what it actually purposely laid down as if they lend support to assert or protect any and everything claimed as being part of the religious right, ritual, observances and method of worship and make such claims immutable from any restriction or regulation based on other provisions of the Constitution or the law enacted to implement such constitutional mandate deserves only to be rejected as merely a superficial approach by purporting to derive what otherwise has to have a really an overriding effect in the scheme of rights declared and guaranteed under part. Any custom or usage, irrespective of even any proof of their existence in pre-constitutional days, cannot be counted as a source of law to claim any rights when it is found to violate human rights, dignity, social equality, and the specific mandate of the constitutional law made by Parliament. No usage which is found to be pernicious and considered to be in derogation of the land or opposed to public policy or social justice can be accepted.
What's the
On the other hand, Seshamal expressly considers the argument based on caste. And that a person, this is extraordinary. And that's a constitutional bench judgment. After reading the next judgment, I will go back to Seshamal. This is an extraordinary reading of Seshamal's judgment. How could this bench of two honorable judges?
We also have limited because this is also a two-judge bench. So keep that in mind.
No, I am saying my lords are bound by Seshamal, which is a constitutional bench judgment. My lords are not bound by this two-judge bench judgment, which doesn't deal with the issue. And interestingly, today, my lords have adopted the inversion test. A ratio of a judgment will have to be tested by adopting the inversion test. When the court takes the view that on the facts of that particular temple, nothing has been proved in regard to custom or usage, etc., or about the denomination, and therefore it is unnecessary to go into it, all other observations are completely beside the point issue. That is not ratio. That can't be treated as ratio. That is not binding on my. That's a submission. I'll give the reference. My lords, there are two judgments where inversion test has been applied. That's in regard to the tribunal appointment. Gujarat judgment. Justice Kaul speaking for a bench of Justice Chalmeshwar and himself. And the second one, subsequently, I think Justice Kaul, Justice Sinha writing a judgment on behalf of the bench of Justice Kaul and himself. The two tests. I'll give the cycle. Since the question I wrote from memory. Kindly now come to Adi Saiva Sivacharya. In my compilation at page 328, 2016 2 SCC 725. Give the reference. Yes, State of Gujarat, the inversion test, 2018 6 SEC, page 21. State of Gujarat versus utility users. And this is also okay. It follows. Well, kindly come to my compilation, page 328. Small 350. Well, in Seshamal's case, yes, Seshamal's case, the challenge was to the abolition of the hereditary right. And two, the rules which empowered the state to make rules, the rule-making power, which empowered the state to make rules prescribing qualifications, etc. The court took the view that that power to make rules, etc., and you are right to direct the trustee to make appointments, it can only be to the extent where it excludes the hereditary right. To that extent, the usage can be excluded. In all other respect, the usage and custom of the temple, of the denomination, etc., have to be followed. If particular agamas have to be followed in regard to the temple, that will have to be followed.
This portion transgressed that. Where has this portion transgressed that is what we are asking.
That is not considered. In this judgment, that part is not considered.
What has it? There's not. It may not have considered, but there is. What is the portion which, according to you, is objective?
It doesn't take. According to me, by saying that what is being pointed out is none of the earlier decisions rendered before Seshamal relate to consideration of any rights based on caste origin. This is wrong. Venkatramana Devaru considered it. Venkatramana Devaru considered the state at various places right of entry of particular persons to what extent and at what stages can be considered. Venkatramana Devaru considered, I will place it. And secondly, even Seshamal case dealt with only facet of the rights claimed on the basis of hereditary succession, not right. One is that, but all other usage, custom, etc. should be followed, is the holding of Seshamal. Otherwise, it will be violative of Article 25, 26. That is not even referred.
What's the next?
Yes. Now, Millard, the judgment in Adi Saiva Sivacharya, 2016 2 SEC 725. That's at page 328 of my compilation. Page 328 of my compilation.
Which page? Which page?
Page.
We will discharge the board. We don't want all of you to wait. Sorry for that. We should have told you earlier. All right. Yes, tell us.
Where citation is
2016 2 SEC.
Volume 2 SEC 725.
725. This is at which compilation? Where?
In my compilation at page 328. 328. Fun.
All right.
Now let
The info luggage, right? Your side will complete today.
complete judgment. Yeah.
He's here for 5 minutes.
We will complete.
Yes.
We had referred only to the paragraph. And my,
Yes. In your written, sir. Yes, that's right.
no,
Right.
in our compilation,
Compilation.
we didn't take your lordships
To the unnecessary part.
only the relevant paragraph.
Remember that.
Query, your lordship wants us to make compilation. Should it be, my lord, issue-wise, like Pachakas in one place, etc.? Or should
Will it be again replicated? Okay, you could do it like that.
Because there is much in these compilations which is a little baffling. Mr. Bhatt has devoted 100 pages to the Irish constitution with the Gaelic version.
We have no control on that. what you file.
And the only relevant part is section 44. But at any rate, we'll try and do it chronologically.
Thank you. Yes.
I must compliment Professor Dhawan. He has made an extensive study. In fact, he has written articles earlier. Therefore, my learned friend's knowledge is very deep in these matters.
Undoubtedly.
Kindly come to page 341 of the compilation.
What somebody called me almost famous. Even that was a compliment.
Who is that?
Almost famous, they say it because they will keep it open-ended so that you will strive further.
That is an exaggeration according to me.
No.
Page 341, para 6.
341.
Para 6 of the judgment. The aforesaid section, that's section 55 of the Hindu Religious Eternity Act, Tamil Nadu, was amended along with other related provisions by the Amendment Act of 1970, which came into force on 8.
1 minute, huh?
Looks like I'll take the rest of the morning session.
Yes, so there's the lesson. Would you like to say?
No?
Okay. 6.
You can point of this balance, the 16.5, which has actually gone on office. It's easy. Yes. Para 6 at page 341. The aforesaid provision was amended along with other related provisions by the Amendment Act of 1970, which came into force on 8/1/1971. By the aforesaid amendment, the principle of next in line of succession was abolished. Amendment came to be challenged before this court, which challenge was considered by a constitutional bench of this court. In its judgment in Seshammal, while upholding the validity of the amendment, dealt with a further question, namely, though the principle of next in line was validly abolished, whether the appointment of office bearers or servants of the temple is required to be made from a particular denomination, group, sect, as mandated by the Agamas, that is, treatises pertaining to matters like construction of temples, installation of idols, and conduct of worship of the deity. The Constitution bench, after an elaborate consideration of the matter, details of which will be noted subsequently, seems to have answered the aforesaid question in the affirmative. This is the in my respectful submission, correct understanding. Now, my lord, the arguments are all noticed, and my lord, I'll skip those, and my lord, kindly come to para 28. A reading, page 350 of the compilation.
Yes.
A reading of the judgment of the Constitutional Bench in Seshamma shows that the bench considered the expanse of Agamas, both in Shaivite and Vaishnavite temples, to hold that the said treatises restricted the appointment of Archakas to a particular religious denomination, and further, that worship of the deity by persons who do not belong to the particular denomination may have the effect of even defiling the idol, requiring purification ceremony to be performed. Constitutional Bench further held that while the appointment of Archakas on the principle of next in line is a secular act, the particular denomination from which the Archakas are required to be appointed as Agama embody a long-standing belief that has come to be firmly embedded in the practices immediately surrounding the worship of the image, and therefore such belief practices constitute an essential part of the religious practice, which under Section 28 of the Act, the trustee is bound to follow. Above, with the petitioner's content with the true ratio of the law laid down by Constitutional Bench in Seshamma, has been questioned by the respondent, who argued that Seshamma is but the expression of an agreement by the Constitutional Bench to what was a concession made before it by the Advocate General of the state. According to the respondent in Seshamma, the Constitutional Bench had no occasion to deal with the issue arising therein. Herein, the challenge before it being confined to the validity of the Amendment Act. Answers to the above will be dealt with a little later. Then, Miller, kindly come to para 31, where Aditayan is referred to. Upon a consideration of the various earlier decisions of the court, specifically referred to in Aditayan, details of which need not again be noticed herein, including the decision in Seshamma, it was held that rights claimed solely on the basis of caste cannot enjoy the protection of Article 25 and 26, and no earlier decisions, including Seshamma, would support the contention that even duly qualified person can be barred from performing puja on the sole ground that such a person is not a Brahmin by birth or pedigree. After expounding the law in the above manner, it was held in Aditayan that even proof of any such practice in the pre-constitutional days, which in any case was not forthcoming, cannot sustain such a claim, as the same would be in derogation of constitutional values and opposed to public policy of social decency. We do not see how the above view of this court in any way strikes a discordant note with the views expressed in any earlier decision, including Seshamma. Issues in Seshamma were entirely different, and the discussion therein proceed on the basis that the entry into the sanctum sanctorum for a particular denomination is without any reference to caste or social status. Reference to the opinion of Sri Parthasarathi has been referred to in the above, and so undisputed scholar was cited to show that apart from the followers of four traditions, so far as Vaishnava tradition, none others, however highly placed in society as Pontifex Acharya, or even as a Brahmin could touch the idol, do puja, or even enter. Exclusion solely on the basis of caste was not an issue in Seshamma. So as to understand the decision in Aditayan to be in any way a departure from what has been held in Seshamma. After discussing all this, the court holds that, now kindly come to page 364, para 48. Kindly come to para 48. Seshamma is not an authority for any proposition as to what an agama or set of agamas governing a particular or group of temples laid down with regard to question that confronts the court, namely whether any particular denomination of worshippers or believers have an exclusive right to be appointed as archakas to perform the puja, much less as the judgment take note of the particular class of caste to which the archakas of a temple must belong, as prescribed by the Agama. All that it does and says is that some of the Agamas do incorporate a fundamental religious belief of the necessity of performance of the pujas by Archakas belong to a particular and distinct sect, group, denomination, failing which there will be defilement of deity, requiring purification ceremony. Surely, if the Agamas in question do not prostrate any group of citizens from being appointed as Archakas on the basis of caste or class, the sanctity of Article 17 or any other provision of Part 30 of the Constitution or even the Protection of Civil Rights Act will not be violated. What has been said in Seshama is that if any prescription with regard to the appointment of Archakas is made by Agama, Section 28 of the Tamil Nadu Act mandates the trustee to conduct the temple affairs in accordance with such custom or usage. Requirement of constitutional conformity is inbuilt, and if a custom or usage is outside the protective umbrella afforded in NSR by Articles 25 and 26, the law would certainly take its own course. Constitutional legitimacy naturally must supersede all religious beliefs or practices. Difficulty lies not in understanding or restating the constitutional values. There is not an iota of doubt on what they are, but to determine whether a claim of state action in furtherance thereof overrides the constitutional guarantees under 25 and 26 may often involve what has already been referred to as a delicate and unenviable task of identifying essential religious beliefs and practices, sans which religion itself does not survive. It is in the performance of this task that in the absence of any exclusive ecclesiastical jurisdiction of this court, if not other shortcomings and inadequacies, that can be felt. Moreover, there is some amount of uncertainty with regard to the prescription containing the organ. Coupled with the above is the lack of easy availability of establishment and the declining numbers of acknowledged and undisputed scholars on the subject. In such a situation, one is reminded of the observation, if not the cotton note, struck by Justice Mukherjee in Shirurma with regard to complete autonomy of a denomination to decide as to what constitutes an essential religious practice. A view that has also been subsequently echoed by this court, though as a minority view. But we must hasten to clarify that no such view of the court can be understood to be an indication of any bar to judicial determination of the issue, as and when it arises. Any contrary opinion would give rise to large-scale conflict of claims and usage as to what is an essential religious practice with no acceptable or adequate forum for resolution. That apart, the complete autonomy contemplated in Shirurma and the meaning of outside authority must not be thrown out of control. Indeed, the views already expected came to be reported. Exclusion of all other authorities from deciding what is an essential religious practice must be viewed in the context of the limited role of the state in matters relating to religious freedom as envisaged by Article 25 and 26 itself, and not of the court as the arbiter of constitutional rights and principles. What then is the eventual result? The answer defies a straightforward resolution, and it is a considered view of the court that the validity or otherwise of the impugned due would depend on the facts of each case of appointment. What is found and held to be prescribed by one particular or a set of agama, or a solitary or a group of temples, as may be, would be determinative of the issue. In this regard, it will be necessary to re-emphasize what has been already stated with regard to the purpose and effect of Article 16.5, namely that exclusion of some and inclusion of a particular segment or denomination for appointment of archakas would not only violate Article 16.5 will come in the case of appointment of public office. It's not in regard to temples, religious denomination, private it may be a place of public worship. That doesn't mean it becomes public employment. Article 16.
So they put it on the ground that once you say appointment is secular,
Yeah.
that is how 16.5 gets.
Yeah. But 16.
Having held that appointment is secular. No, 16 of course doesn't talk about any secular post. 16 is in the context of public employment.
Yes. PC 16
Yes, public employment.
deals with equality of opportunity in matters of public employment. Now, there are very often happens that there are a number of corporate entities I know in Tamil Nadu, they have followed a policy of preferring persons belonging to the caste from which they come. If it is a Brahmin, if it is, I know there are institutions set up by Nagas, there are institutions set up by Naidus. They prefer persons coming from that particular caste, whatever faith, but that they have confidence in them. There are persons who belong to caste, if it is a Brahmin institution, they have preferred it. But these are not matters of public employment. That's a matter of private employment. Now, please come to sub-article 5. Nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. Now,
because under the Endowments Act, the appointment of all the administrators partake the character of public employment. Though the entirety of the funds for the commissioner, additional commissioner, all the commissioners come out of the funds received from temple donations, but those officers are public officers.
They are. I'm not quarreling with that.
They are. So
commissioners, assistant commissioners, even executive officers. But Miller, an Archaka.
That very statute talks about appointment and process of appointments of Archakas also.
When the very fundamental basis in regard to
the
appointment of or of running of a temple is to be for a limited period in the case of maladministration, it can't be, it is permanently becomes an institution of public employment.
Read for that.
Yes. It can't be, that will be completely contrary.
Just read from here again. It will be necessary to re-emphasize what has already...
In this regard, it will be necessary to re-emphasize what has been already stated with regard to the purport and effect of Article 16(5) of the Constitution, namely, that the exclusion of some and inclusion of a particular segment or denomination for appointment of Archaka would not violate Article 14, so long as any such exclusion is not based on the criteria of caste, birth, or any of the constitutionally unacceptable parameters. Now, if the Agama says a person belongs to a particular faith, particular denomination, then should be there. That manner, in my respectful submission, that is not necessarily only based on caste. It is based on various factors. So long as a prescription under a particular agamas is not contrary to any constitutional mandate, as discussed above, impugned geo dated so by its blanket fear to the effect that any person who is a Hindu and possessing the requisite qualification saying can be appointed as an Archaka in Hindu temple has the potential of falling foul of the dictum laid down in Saishama. A determination of the contours of a claimed customs or usage would be imperative, and it is in that light that the validity of the impugned geo will have to be decided in each case of appointment of Archakas, whenever and wherever the issue is raised. Therefore, the geo...
How did it work out in reality? We are asking you. He kept it open-ended. The decision will be depending on the case-to-case basis.
Did
it lead any further litigation?
Fortunately, the government has not attempted. When it attempted to make some persons who have been trained in particular institutions to be appointed as Archakas, there have been challenges in court, and court has granted some kind of an interim order. So far, that has not come into
directly arise in this case. This whole thing about talking about this particular agama, because your statute is concerned, it's a over breadth, perhaps at the most, you can say it's an over breadth.
Yes. Section 9.
But to get into all these would require us to get into the correctness of each of those judgments. But independent of that, your initial argument that it is on an over breadth and it doesn't take into account the nuances those were required is alternative argument that you have made. We have heard you.
That's right. That's good.
Then that takes you to what?
Therefore, my respectful submission is section 10, section 9 and 10, if it is conferred of the Karnataka, if it is construed as conferring a power enabling the committee of management of a notified institution to appoint any person who is qualified.
Enable the committee of management. What is it called?
Yes, committee of management, section 9. Section 9 talks of committee of management of a notified institution.
Oh, so?
Notified institutions are those...
I know that. We know that. If it is construed to enable the committee of management of notified institutions,
but to appoint any person who fulfills the qualifications prescribed under section 10 without reference to the custom, usage and traditions of the temple, including agamas, then Miller, I respectfully submit it will be violative of Article 25 and 10. It will necessarily have to be
next.
It will necessarily have to be read down in the manner done in Seshamal, otherwise it will fall foul of 25 and 20. Now, I'm done with the appointment of Archaka. On the question of religious denomination, I will indicate my broad submission and then go into the question. Now,
what does the Act do about denomination?
I'm sorry?
What does the Act do?
The Act provides... Yes, section 1.4.
You showed us the amended.
Section 1.4. There is some back in. No, not section 1.4. Exclusion of
1.4 denomination.
1.4.
Which denomination? Denomination is excluded. Then amendment.
Section 35. No, not.
All denominations are included.
Oh.
Initially, denomination was excluded. Subsequently, all denominations are brought in. Am I right? By amendment, what has happened?
I'll just give.
Been a gap since Mr. 1.4, right? Section 1.4.
No, section 35 as amended.
Section 35?
As amended. Except section 41.
Unamended is 170, amended is 207.
Yeah.
39.
239. Amended, except section 41 and the provisions of chapter 8, nothing contained in this act is applicable to any religious institution or charitable endowment founded, organized, run or managed by religious denomination. Therefore,
that is what. Yeah. Post amendment.
Yes, post amendment. Now, the question will arise.
So, post amendment, it gets excluded.
Religious denomination will stand excluded from applicability of various provisions of the Act, except section 41 and provisions of chapter 8. Chapter 8 deals with Case of mismanagement, maladministration, where an administration can be taken over temporarily for a limited period after giving show cause notice, etc. Now,
So the position is clear.
Yes.
As the act was initially enacted,
yes,
denominations were within the net of the act.
yes,
Post amendment, denominations were excluded. Correct or not?
correct.
He is denying that. What is the position?
But here these it has been made inapplicable. Yes, correct. Therefore, that's right. Now, question will arise, therefore, for the purpose of determining whether the remaining provisions of the Act will apply or not, as to whether the temple in question is a temple which has been founded, organized, or run or managed by a religious denomination. So, question will arise as to what is a religious denomination.
But this
The
position
problem-
we don't want a confusion. This position is very clear according to you. That earlier denominations as such.
Some of the denominations stood excluded, but others were included. Even denominational institutions
once it's a denomination, it was included. After the amendment, they have excluded denominations. Now, please show us that. I mean, we have to be clear. You have to get the act, please.
Chapter 8 so does not apply. Now chapter 8 applies to denomination, that's the change.
We don't want to be
Yes.
unclear about that.
Section
Act
1(4).
का volume है ना? The act volume, Pratik, is in which one?
It's in the SLP itself.
The second volume.
Civil Appeal 4103,
देखिए.
both the acts are there. 4103.
Just agree on that fact so that there's no confusion.
Subsection 4 of section 1, original,
169, where Lord was not.
1 minute, he's giving it. Denomination?
State of Karnataka versus Sri Mahaganpati Shankara.
नहीं, last time था ना.
Yes, my lord, mark this. Holy Lord.
You have flags है सारे. हाँ, वो कहाँ है? आपके पास देखो. ये नहीं, तो वॉल्यूम है.
originally,
Just tell, you in your own words, tell us what was the position originally.
originally all denominational institutions were excluded. Now,
What are the relevant provisions?
section 1, subsection 4,
Yes.
it shall not apply to mutt or temple attached thereto, then to any Hindu religious institution or charitable endowment founded, organized, run or managed by Hindu religious denomination. That is also original. Now, that has been substituted. It shall apply to all religious institutions notified under section 23, and chapter 8 shall apply to all religious institutions or charitable endowments other than those notified under section 23, provided that it shall not apply. But having said this, there is a further provision, yes, section 35.
ये नहीं. ये करीब. I'm not very clear.
Got one more.
Wait a minute.
But act as it were,
Yeah.
originally applied to all and excluded denominations were excluded under 1(4).
Yes.
Originally, as it were.
Yes.
Denomination under 1(4) is excluded. Now, how have denomination come back under the amendment? Just show us the provision.
That is by the amendment.
Show us the provision, please.
Yes. Say, in the chart, my lord will see.
No, from the act, Pratik, page.
Section.
39, 239 is 35, and my lord will have 1(4) and
230.
239 and 209. 209 is 1(4) and 239 is.
Applicability, section 35.
But 1(4) is also.
1 minute, except provisions, chapter 7, chapter 8, nothing contained is applicable to any religious institution, charitable or founded, run or organized religious function. Except chapter so the way to read it is that except chapter 3,
Yes.
nothing in this act is applicable to a denomination.
Yes,
Chapter 8, nothing in it.
Yes.
So therefore, the amended provision excludes denominations
Yes.
except for chapter 8.
Okay. Well, original act, but now chapter 8 has been made applicable. Even chapter 8 was not applicable earlier, now that has been made applicable.
Earlier, even chapter 8 did not apply.
Now it applies.
That's the only distinction.
Correct, that's a distinction. But therefore, we have to know
Your challenge, therefore, is applicability of chapter 8
chapter 8.
and the definition of denomination. Not applying at all. Till here we are clear. Okay. So applicability of chapter 8 is your trouble.
No, second, two aspects.
Definition.
Whenever, in regard to chapter 6 applicability also, if somebody is questioning, saying that it's not applicable on the basis that I belong to a religious denomination, then the question will arise as to whether that institution is a religious denomination. Question will then...
The test of religious denomination.
Yes, that will have to be decided. Now, the problem is...
You might claim as a religious denomination which may be denied
Yes.
because of the precedence of how a
Correct.
denomination.
Therefore, now one has to necessarily define what will be the religious denomination.
All right.
That is a question that may have...
No, addresses on that.
Now, in Shirur Mutt,
Clarification. I have one question to ask, just so that my own mind is clear. Do they want religious denominations to be in the act or?
we don't want it to be in
If they
that.
out of it, the entire regime goes.
We want it to be out of that.
You want to be out. So that's good, we agree with that. And as far as chapter 8 is concerned, it is only concerned with mismanagement,
Correct.
which my learned friend in his opening endorsed. So the problem is not whether they want to be in or out, and my learned friends, they want to be out.
Yeah.
I agree with that.
Then how?
It fell from your lordship, what is your real grievance? And I just need clarification on that.
If therefore my learned friend so graciously agrees that the religious denominational institutions will be out, I ask myself, how is it that 35,000 institutions in Karnataka are treated as being controlled by the Act because a large number of them are institutions set up by religious denominations?
Does the act talk about what is a denomination? How does it deal with?
Fine.
Let us see that.
Subsection. Kindly
You
see.
start from that.
Yes.
Section 260. You start from that.
Yes. Section 2. Amendment.
Originally, section 216 said that Hindu would not include Sikhs, Buddhists and Jain. That has now been deleted.
You told us that.
And now it has been substituted by this particular one.
Subsection 2.
212, page 212. Collection of Hindu individuals classed together in the same name, a Hindu religious section or subsection.
Originally,
Or a section thereof.
subsection 16 of section 2, that is clause 16,
That you will get it
it defined only
page 100 and
it did not define religious denomination. It defined Hindu does not include a Buddhist, Jain or Sikh. Now, Miller, that has been substituted by Hindu religious denomination.
Correct.
Means a collection of Hindu individuals or devotees classed together under the same name, a Hindu religious section or subsection or body or a section thereof, or the spiritual fraternity represented by it, having a common faith, rituals, observances, ceremonies, and mode of worship, which is designated by a distinctive day. Now, this application of this definition in individual cases, in my respectful submission, will be not consistent with the manner in which the expression Hindu religious denomination has been understood in the Constitution. If this is, I believe the whole object of the amendment of the statute is to ensure that the statutory provision is in accordance with the requirement of Article 26 of the Constitution to protect the rights of religious denomination under Article 16, Article 26. If that is so, now what will be a religious denomination will have to be considered. Now, my lords are aware this has been considered in Shirur Math and some of the other cases. But that has not noticed the Hindi version, which later came in 1987. The provisions in the Constitution.
Sampradaya.
Dharmic Sampradaya.
No,
Sampradaya, if I am not wrong. That's what.
Yes. Dharmic Sampradaya. Now, kindly see 394A first, Article 394A of the Constitution.
Sampradaya.
There must be more.
I have one copy of Hindi.
You got the other. 394 capital A.
Okay.
This is inserted by the Constitution 58th Amendment Act 1987, with effect from 9/12/1987. The President shall cause to be published under his authority.
What are you reading? 394?
394 capital A.
Ah, yes. Authoritative text
Yes.
in Hindi language.
In the Hindi language.
Oh.
This is introduced by the 58th Amendment Act with effect from 9/12/1987. The President shall cause to be published under his authority the translation of this Constitution in the Hindi language, signed by the members of the Constituent Assembly with such modifications as may be necessary to bring it in conformity with the language, style, and terminology adopted in the authoritative text of the Central Act in the Hindi language, and incorporating therein all the amendments of the Constitution made before such publication. And the translation in the Hindi language of every amendment of this Constitution made in the English language. The translation of this Constitution of every amendment thereof shall be construed to have the same meaning as the original thereof, and if any difficulty arises in so construing any part of the translation, President shall cause the same to be read faithfully. Translation and every amendment thereof shall be deemed to be for all purposes the authoritative text thereof in the Hindi language. Now, under this, the Article 26, the Hindi version, I believe my notes have been given a Hindi version. I have, otherwise, post lunch I'll give copy.
No, what's the point? Can you formulate?
Because this now, the religious denomination, the expression used in the Hindi version is Pratyek Dharmik Sampradaya. Last time, I referred to Shirur Mat case where in para 16, the Oxford definition of religious denomination is quoted. Today, in the context of the Hindi version, Pratyek Dharmik Sampradaya, I have serious doubts. Fortunately, that Shirur Mat case, which is a 7-judgment judgment, did not apply those 3 tests cumulatively. But
Which 3 tests?
the 3 tests mentioned in paragraph 16, that is the Oxford dictionary test, that was not applied in Shirur Mat case cumulatively. But in SP Mittal, Aravindo case, the majority treats it as if it has to be applied cumulatively. Where, in fact, Justice Chinnapreddy in his dissent doubts that correctness of that and says that Shirur Mat didn't say that. Now, interestingly, in Tilakayat Govindalji and Dargah Committee, where Vallabha followers, whether they constitute religious denomination or not, there again, huge number. The court proceeds on the basis they constitute religious denomination. In the Dargah Committee case, that is in regard to the Sufism. Sufis constitute denomination. And here, Vallabha followers. Now, strangely, thereafter, whatever SP Mittal said, a line of decision has come in Kashi Vishwanath's case and also followed in Guruvayur Devasam, Millet Guruvayur Devasam, which refers to Kashi Vishwanath, where applying the test of, this is a temple where, Kashi Vishwanath temple, anybody, whether he is a believer in Shaivism or Vaishnavism, can go. Therefore, this temple cannot be. That was never the test. Question is not, it's a place of public worship. Anybody can go. In fact, I have serious issue with regard to some persons proposing that only a particular class of people should be allowed to enter temples, or for that matter, even only Hindus should be allowed to enter temples. There are temples where, like for example, Sabrimala, nobody insists that only a Hindu should go. There are temples which allow worship by others. There are, of course, other temples which impose restrict. But question of whether